Today, we're diving into a highly practical and honestly, absolutely crucial part of civil procedure 2. We're looking at the enforcement of judgment from A to Z. Basically, we're going to demystify exactly what happens after the trial ends, because here's the harsh truth. Winning in court, that's really only half the battle. Our entire focus today is on how you actually turn that hard-fought courtroom victory into real, tangible results. Let's get right into it.
So picture this classic scenario. You did it. You just won the case. The judge ruled in your favor. You are thrilled. But where is your money? We really need to dispel this whole Hollywood myth that a trial ends with a dramatic strike of a gavel and someone immediately handing you a briefcase full of cash. That is just not how it works. In reality, a victorious plaintiff, who is now called a judgment creditor, often finds themselves holding nothing more than a piece of paper, staring down a stubborn debtor who flat out refuses to pay up. It is incredibly frustrating, right? That piece of paper is literally useless unless you know how to enforce it.
So here's our game plan for today. We're going to hit 5 key stops on this roadmap. 1. From judgment to execution. 2. Discovering the hidden assets. 3. Seizing and selling property. 4. Garnishee proceedings explained. And 5. Enforcing non-monetary judgments.
Okay, kicking things off with Section 1, moving from that initial judgment to actual execution.
Before we can enforce anything, we have to know exactly what kind of court decision we're holding. There's actually a critical difference between a judgment and an order in civil procedure. To tell them apart, courts use something called the Bonzen test. This comes from the Bonzen versus Altrincham Urban District Council case. Under this test, a judgment is a final decision that completely disposes of the rights of the parties. Think of a summary judgment or a default judgment. It's the end of the line. An order, on the other hand, is merely interlocutory. That just means it's a temporary or procedural step along the way, like an order to amend your pleadings. So, for our purposes in enforcement, we are primarily dealing with final judgments.
While we're defining things, we also need to clear up execution versus enforcement. People use them interchangeably all the time, but legally they are different. Execution is highly specific. It refers strictly to the specific writs found under Order 46, Rule 1, things like a writ of seizure and sale, a writ of possession, or a writ of delivery. Enforcement, however, is the big umbrella term. It covers absolutely all methods of collecting on a judgment. So it includes those specific execution writs, sure, but it also covers the whole shebang of other strategies, like garnishee proceedings or charging orders.
All right, moving on to Section 2, discovering the hidden assets. Because obviously, you can't seize what you can't find.
Now, the law gives us 2 distinct ways to examine a debtor, and honestly, they pack very different punches. On one side, we have Order 48 of the Rules of Court. Think of this as purely a discovery tool. You apply ex parte, which means you do it without notifying the debtor just yet, and the court orders them to come in and be orally examined by the registrar. They have to spill on what debts are owed to them and what property they own. But here's the kicker. The registrar can't actually order them to pay you during this process. Then, on the other side, we have Section 4 of the Debtors Act 1957, and wow, this one is much stronger. Under Section 4, the court examines the debtor's actual ability to pay. And crucially, the court can immediately order the debtor to pay the debt right then and there, either in a lump sum or in installments. If they default on that order, well, Section 4 carries the heavy threat of committal proceedings. We're talking actual prison time.
When you look at the actual procedural rules side by side, you can really see the difference. Order 48, Rule 1, Sub 2 outlines that ex parte application process for the oral examination. But right next to it, the text of Section 4, Sub 1 of the Debtors Act lays out the statutory power to summon the debtor. Pay special attention to Sections 4, Sub 6, and 4, Sub 7 through 9. These are the exact specific provisions that empower the court to compel payment and literally throw a defaulting debtor into prison. As a frustrated creditor, this is a massive, massive point of leverage for you.
Which brings us to Section 3, seizing and selling property. The hunter is finally going after the physical target.
So if you're going after property, you have 2 heavy-hitting tools depending on what you're trying to take. For movable property, we're talking cars, electronics, expensive furniture, you use a writ of seizure and sale. This writ commands the sheriff or bailiff to go in, seize the goods, and sell them off by public auction. Once it's issued, this writ gives you a 12-month window to act. But what if your debtor's wealth is tied up in a house or a piece of land? I mean, you can't exactly load a house into a moving truck. For immovable property, you need a prohibitory order. This order essentially freezes the land. It strictly prohibits the judgment debtor from transferring, charging, or leasing that property. Now, a prohibitory order has a much shorter lifespan, just 6 months. And during that countdown, the creditor actually has to apply to the court for a separate order to sell the land.
Now,
Here's the catch. You can't take absolutely everything a person owns, even if they owe you a massive fortune. The law does step in to protect basic human dignity. Section 3, Sub 1 of the Debtors Act sets out some very strict exceptions of what cannot be seized during a writ of seizure and sale. You absolutely cannot seize the person's wearing apparel, their cooking vessels, or their beds and bedding. You also can't take the tools of their trade up to the value of RM 200, and you cannot touch their wages or salary.
And the protections actually go even further, especially if the debtor is an agriculturalist. You cannot take their implements of husbandry, their cattle, their seed grain, or the houses they occupy that are absolutely necessary for them to earn a living. Notice, too, that the law completely exempts any pension, gratuity, or allowance granted by the government. The underlying philosophy here is pretty clear. The goal of execution is to satisfy the debt, absolutely, but not to leave the debtor completely destitute and literally unable to survive.
All right, moving to Section 4. What if their money isn't in the car or a house, but sitting in the bank account? Let's talk about garnishee proceedings.
For this, we use Order 49. First, let's just define the garnishee. Basically, a garnishee is an innocent third party, like a bank, that happens to be within the court's jurisdiction and is holding money that rightfully belongs to the judgment debtor. But, and this is a critical but, there's a strict catch. The money held by the garnishee must be strictly due or accruing due to the judgment debtor. It has to be a fixed, precise, unquestionable sum. A fluctuating amount or some unconfirmed debt, that simply won't work.
The beauty of Order 49 is that it breaks this highly effective procedure down into two really logical steps. Step 1 is the order to show cause, which you might hear called the order nisi. This acts as a temporary freeze. The creditor applies ex parte, and boom, the court issues an order that immediately freezes that specific debt in the hands of the garnishee. Then comes Step 2, the hearing for further consideration, or the order absolute. 7 days after the garnishee is served with the freeze, everyone meets. If the garnishee doesn't dispute that they hold the debtor's money, it's easy. The court makes the order absolute, legally forcing the garnishee to hand that money directly over to you, the judgment creditor.
To show you just how strict this due or accruing due rule actually is, let's look at the fascinating case of Chung Hang Loon Goldsmiths versus Chan Kim Sui. So in this case, a debtor's goods were robbed and they filed an insurance claim. The clever creditor tried to swoop in and garnish that insurance money, but the court said absolutely not. Why? Because the insurance company hadn't actually admitted liability for the claim yet. Since the claim wasn't formally approved, it wasn't a precise admitted debt. It's a brilliant example highlighting that you literally cannot garnish a potential or unadmitted claim. The money has to be securely, undeniably owed. But, things don't always go that smoothly. What happens if the garnishee actually shows up to the hearing and disputes the claim? Well, under Order 49, Rule 5, the court has some options. The judge or registrar can determine the dispute summarily, right then and there. But as case law like Sherry Cat, Long Lee, and Trading shows us, doing it summarily actually requires the consent of the parties. If they don't consent, or if the issue is just too complex, the court will order the liability of the garnishee to be determined in a formal trial in open court, so it can get drawn out if there's a real dispute.
Okay, bringing it home with Section 5, let's look at enforcing non-monetary judgments, because sometimes it isn't about the money at all. For this, we look at two distinct writs under Order 45. Let's say the judgment is for the recovery of immovable property, meaning you literally need to evict people and take back a piece of land or a building. For that, you use a writ of possession. This commands the sheriff to enter the land and physically take possession for you. On the flip side, what if the judgment is for movable property? Say you need to reclaim a very specific stolen car or a unique piece of heavy machinery. For that, you use a writ of delivery. This commands the sheriff to go seize that specific movable item and hand it right back to you.
But seriously, beware the strict rules established in the case of Liang Ao Weng versus Neo Thien Su. In this case, the parties had a consent order extending a lease, but the order itself never explicitly commanded the actual handover of possession. When the landlord tried to send in the bailiffs using a writ of possession based on that order, the federal court stopped them in their tracks. The prerequisite for a writ of possession is that you must have a flawless, valid judgment or order that